Now, in the Sambhal case, the petitioner is advocate Vishnu Shankar Jain. He joins us on this special broadcast. Before I throw it open for a wider discussion, I want to bring in Vishnu Shankar Jain for more on this. Vishnu Shankar Jain, there are several mosques, including the Sambhal Shahi Jama Masjid, Mathura's Shahi Eidgah, the mosque at Badaयूं, where claims are being made that this was where a temple stood, including the Bhodshala in Madhya Pradesh, where you've taken up the case once again. Now, is there a wider trend in this? What is it that you're hoping to achieve? Initially, we were told that it's Ayodhya, then Mathura, then Kashi, but now there appears to be a bigger case, sir.
It is not about trend, it's about a judicial right. If the people of this country have a right to reclaim back their temples which were destroyed, then definitely a legal right accrues, and as per the legal right, you can file cases before the court. The point is that as per Shastric Niyam of the Hindus, once a temple, always a temple is a basic Shastric Niyam which is being followed, which has been also delivered by the Honorable Supreme Court in Ram Mandir case. So if there was a pre-existing temple at any point of time, definitely you have a legal right to reclaim it back. And it is also, as per Islamic law, in violation of Islamic law, because no Islamic scholar can say that you can build a mosque after demolishing a Hindu temple. And many cases, so far as Gyanvapi is concerned, the entire evidence which we have found in Gyanvapi case is saying that it's a precincts of an old Hindu temple. The evidence which is there in Mathura Shri Krishna Janmabhoomi case, where survey is yet to happen, will also prove to the hilt that there was a pre-existing Hindu temple. In Bhodshala case, survey was already conducted and the ASI has come to a conclusion that this was a pre-existing Hindu temple. So that's why this survey and all these things are objected, because they know that the truth will come out.
Okay. So it is a Hindu right to know the truth and reclaim their places of worship is what you insist. How do you interpret the timeline of events like in the Chandosi mosque inspection case, where the petition, the approval and the survey all executed within hours, where parties like the Samajwadi Party or some who are representing the cause of the Muslim side say that all of this appears planned to vitiate the atmosphere? Does the pace raise concern about due process of law being followed and the potential for communal unrest?
Yeah, I understand your question, Rahul. See, the point is that people who are objecting to the procedure which have been adopted by the court, they actually do not know the legal procedure which is followed under the CPC. If you will go and interview various lawyers under the civil code, under the CPC, the surveys are ordered regularly, and it is not like that you present a petition before the court and the matter is heard after 1 day, after 7 days, or after 8 days. In a civil code, when you move a fresh matter, it is listed on the same day at 2 o'clock, and after hearing the parties, ex-party advocate commissioner appointments are ordered. In a routine manner, it is ordered. And I must also quote a judgment of the Supreme Court, 1989, 1 SCC, page 19. In that judgment of the Supreme Court, and there are various other judgments also, Bombay High Court and various other high courts, where the courts have taken a view that advocate commissioner can be appointed ex parte. The only requirement and the only mandate of law for appointment of advocate commissioner is that when he is going to conduct the survey, he has to take along with himself the party who is the affected party, and that's the only requirement. So to say that when you file a petition immediately, the court ordered advocate commission survey and you are prejudiced is against the basic tenets of law, is against the judgments of the Supreme Court.
Fair enough, but what about the Places of Worship Act 1991 that's been quoted very extensively, saying it prohibits any change to the character of the place of worship as it exists on the 15th of August 1947. And the Supreme Court in the Ayodhya verdict, as you're well aware, upheld the Places of Worship Act and stated that historical wrongs cannot justify contemporary disputes.
See, first of all, you have to understand the quotation which you have given, Rahul, of the Supreme Court verdict is a passing remark. It's an obiter and it is not binding. In the same way, I can also quote the oral observation of Justice Chandrachud in Gyanvapi case, where he had observed and said that you can file cases to determine the religious character. So both these legal propositions are not applicable. What is applicable and what holds the field is the judgment of Honorable Allahabad High Court delivered by Honorable Justice Rohit Ranjan Agarwal on 19th of December 2023, wherein he had held, and it's a judicial verdict which has not been stayed by the Supreme Court till date, wherein he has held that you can file cases to ascertain the religious character of a place of worship. And in Gyanvapi case also it has been held that Places of Worship Act is not attracted. So the interpretation the question which you are asking about the Places of Worship Act, according to me, that's not a sound legal interpretation. And with the legal interpretation which I am putting in front of you, the matter is sub judice before the Honorable Supreme Court.
It indeed is. Now, there is historical evidence to suggest, and there are several historians who say that Aurangzeb was involved not just in ordering the destruction at Kashi Vishwanath and Mathura, but also at several other temples. The number varies from 10 to 15 to even more. Some argue that he oversaw the demolition of many, many more temples. It could go into hundreds. Local temples, bigger temples. It was all a part of a military campaign or ordering local governors who were acting on his behalf. Now, are you now suggesting that Hindus should reclaim all such temples that were destroyed either on the instructions of Aurangzeb or other invaders and bigoted emperors?
If there is a proof that temple has been demolished, then definitely there is a legal right which accrues and you have a right to reclaim it back. How much we will reclaim is a matter which will be decided in future after scrutinizing the evidence. But definitely, as per the question which you have asked me, if a temple has been demolished, it is not correct as per Islamic law, and as per Hindu Shastric law, once a temple, always a temple. Okay. You have a right to restore it back.
Vishnu Shankar Jain for joining me here on India Today. Many thanks.